in a couple of seconds. So now let us go more specifically. Now we're getting into the second part of this lecture, and so part 2 እየገባው ነው እንትን section ያሉትን እንትን ለማድረግ ነው. Okay, go ahead a second thing. Okay, so now in the second part, I want you to always be cognizant of the big picture. And that is important because when you come into strategic litigation as a lawyer, you need to have that big picture we covered in the introduction. Now, let's go back to doing strategic litigation. Before we do that, we start with what do we want. We already set what our goal is. So we want to make the playing field equal for women, or fair for women, right? So when we are trying to do that, so we start with what our cause is, and usually if you're working as a group, as part of a team, or even by yourselves, I would recommend writing these things down, having brainstorming sessions where you specifically ask yourself, what is the goal? What are we trying to achieve? And then what can we do to achieve it? So basically you're getting to, is strategic litigation the best thing you can do? Is it the best use of your time and effort? If you have funding, your funding, would it rather be used elsewhere, or should it be used in strategic litigation? If you're dealing with, let's say, enforcement of legislation regarding women or sexual abuse, would you rather go through strategic litigation, or would you use those resources, for example, training law enforcement or training prosecutors? So it is always important, you have all these options, all these things you can do to achieve your goal, and then you have strategic litigation on the other side. So you need to start with this weighing process of pros and cons. And so let's say you have gone through this process and you have decided that yes, strategic litigation is the better way to go. It's worth your investment. Then the next question is, go through this list that I've put on your PowerPoint of a risk-benefit analysis. So if I go through if I start a case, a strategic litigation case, or any case for that matter, what are the risks? So the benefits are, let's say you want enforcement of legislation that the government isn't enforcing, or you want the legislation to be changed, and so that's the benefits. You list your benefit, and then you list your risks. So the risks might be maybe the government will, let's say society will have a backlash against your movement. Maybe there is legislation in Parliament that if your case raises the profile of certain issues, the government might, scrap that piece of legislation. And you always also have to think of your clients, and we'll talk about clients in a little bit. You would, when you go into litigation, in most situations, you would have specific clients. So what are the risks to the client? And for example, your typical risk to a client could be re-victimization by the government, re-victimization by society or certain perpetrators. So when you raise the profile of that case, and in Ethiopia and many sex abuse cases, they're men and their friends and their family members usually try to talk to women who accuse men and try to reconcile with them, sometimes reconciling with them with a certain sense of threatening them. And so you need to have a clear picture of what that client is risking. And as a lawyer, it's an ethical imperative for you to consider that what kind of harm the client is facing, and also communicate with the client what those risks are. So you need to, I would recommend that you make a list of those things. And you also need to consider the risks that you are taking as an attorney, as a lawyer, and the risks that your organization is taking. So in Ethiopia, you might have, especially if you have some experience in lawyering or in litigation in Ethiopia, or in politics in Ethiopia, you will be familiar that the Ethiopian government in the last 2 decades has targeted lawyers, has targeted organizations that do strategic litigation or human rights work in general. So you also need to talk amongst yourselves what the repercussions are going to be for the institution. And this exercise is meant to allow you to anticipate. Sometimes your decision might be, for example, your conversation with your client might be, yes, there will be negative repercussions, and you discuss how to mitigate those consequences. And if you feel that it's worth it, you move on. But since you already know what the potential consequences are, you will be able to prepare for them better. The same with risks to your institution or to the attorneys involved. Might the risk be the illegal suspension of the licenses of the lawyers who take the case to court, or might it be, and this is not hypothetical because this has happened before. Lawyers have either been threatened or their licenses have been cancelled because of their human rights work. So you need to consider that risk, and risk to your organization. Risks to your organizations might be, it could be shut down, your landlord could be contacted and told to cancel your lease. So you weigh those things, and once you weigh those things, your calculations will not be perfect every time, but once you weigh those risks, you will be in a situation to know and anticipate these problems. And the other thing you need to consider is, and I've noticed, I've seen this in a couple of situations where organizations or lawyers get into strategic litigation, but they find themselves overwhelmed by it because they would not anticipate the costs, the financial costs, how long it's going to take, and whether that's timeline is something that they or the client is able to put up with, which means there should be communication with the client as well, communication as to setting the client's expectations. Now, cases, human rights cases or court cases in general are not cheap, they're not cost-free, and so among the things you need to consider, once you've figured out, okay, it's worth going into, you also are in an industry where resources are limited. Resources are always going to be limited. So if you want to sue the largest company or even the government as an employer because of the discrimination that exists within the workplace, one of the things you need to think about is, wait, before I do that, let me make sure that there aren't other institutions that are doing the same thing. And if there are, strategically, you're not doing strategic litigation just because you know the client or the client is your client. You're doing it because you're trying to achieve what's with the goals of the example we started with. So if there are institutions that are doing the same thing, then rather than reproducing that, maybe your resources could be better spent in other ways. So maybe you can collaborate with that institution. Maybe you can join the suit. Maybe it's you have 40 clients who are suing the biggest employer in Ethiopia, and you find out there are other institutions that are doing that, or other lawyers that are doing that. Maybe it's better to join your cases and work together. Maybe if the institution that is doing that, you see that, you look at that institution, they're doing it well, you don't need to reproduce efforts. And maybe if joining them is not the best idea, maybe you have expertise that that institution doesn't have. Maybe you can provide that expertise. If you're from the university, for example, you could provide expert testimony, or you have access to expert testimony that they don't. Maybe you could provide that for them, so that it's done collaboratively and it's done better between you rather than going separate routes. And the other option is, should you provide an amicus brief in support of that institution, rather than doing your own case. So these are it is highly recommended that you go through these steps, and everything that I'm discussing are more recommendations than rules, because when you come to specific cases, the dynamics are going to be so different. But it is important that you go through these questions before you go into strategic litigation. Now, okay, so let's say you are going into strategic litigation. So there aren't any other institutions working on the case. The risks are low, or they're worth it, and you decide to go into strategic litigation. And so the next step that you need to be careful on is selecting your cases. So how and this all comes down to the fact that resources are limited, right? So you want to bring about social change, and in order to do that, you have to find your perfect case. And so you also need to define what specifically, legally speaking, what you want to achieve, what success means. And once you've defined that, you look for cases that fit that goal as much as possible. And this is where I would distinguish between cases that are strategic and cases that aren't. So when you're doing this process, by the way, you might not always have to look for new cases. You might already have clients, and especially if you're a practicing lawyer, you might already have clients that fit that category. So you might want to look at your cases before you go out looking for new cases. So you might retrofit pre-existing cases. So the difference here is that this is where the strategic part, sets itself apart. So just taking one case versus a case of strategic importance is where all the recommendations and checklists that I'm going through help you find the cases that will optimize your efforts. So for example, so making a checklist for case selection is one of the other things that I would recommend. In your checklist, what I would recommend you include is, so my case needs to have XYZ in terms of, for example, it can be used to target specific parts of the Constitution. So you want to see the article on women's rights in the Constitution. You want to apply for. We used affirmative action as an example earlier. So you want to work on affirmative action cases. So it's not just every case you're working on. You're looking for a case that fits your specific need. It's an affirmative action case, then it can be used to argue about this particular legislation or this particular practice of the Ministry of Education. And so making that checklist will help you go through, when clients come into your office, you go through different clients and say, oh, this one is the right fit for a strategic litigation case. And when you do that, one of the things that you should consider is, and this is really the difficult part, but it's very important in that, so you have a women's rights agenda, but then at the same time, since you're working in strategic litigation, since, earlier I talked about how you're looking at legislation, you're looking at using the purse of the government, the powers of the state in order to achieve your goals, or you're trying to prevent the powers of the state from discriminating against women's rights. So there is, because of the nature of your industry, because strategic litigation stands on the notion of the rule of law, you should make a checklist of, in your criteria, you should include cases that support the rule of law as something that's preferable. It's not necessarily in tune with your specific goal, but if there is the rule of law in Ethiopia, you as lawyers can become more effective. So, so I will come back to these maybe later, but so think about how your case will improve the rule of law and constitutionalism in Ethiopia. And when you're doing a strategic litigation case, you could make your case about women's rights, but also about constitutionalism at the same time. So once you have selected your case, or once you have a checklist for case selection, and you have potential clients coming in for your strategic litigation case, and at this stage it's also important to think about it's hard to make criteria for clients, but it's important to think about what your client's relationship to you in the case is. So if you have more than one potential client, you need to look at the client and think about which client is best for my case. And in this regard, you need to distinguish, you need to clearly have a clear picture, and you need to discuss this with the client as well. You need to have a clear picture as to what your client's interests are and what your interests are, and make sure that these overlap to a great extent, because the client will probably want justice achieved. The client would want to win the case, have their day in court, and also the client will want to win the case. And so think about the client's interests specific in regards to that specific case, and then also think about your interest, because your interest is always bigger than the client's, because you are thinking about strategic litigation. You're thinking beyond the client. So you need to discuss what the strategic, for example, might your client, when you're picking your client, if your client will likely drop out of the case or would want to withdraw their application, then if you suspect that they will do that, then that client might not be the best client for that strategic litigation case. And so you need to discuss what the expectations are. If that is a case that you want to take to court for the next 10 years, you need to make sure that the client is on board. Discuss that with the client. Clients can always change their minds. They get priority in terms of you. You have to make sure you don't have conflicting interests, so you need to think about what my interests are, what the client's interests are, And if there's no conflict, you can move on. You have to bring them fully on board. And if it's a situation where you suspect that the client might drop out, maybe it's the nature of the case is one in which clients might drop out. Maybe you need to take 2 clients with the same issue, 3, 4, 5, 6, 7, 8, 9, 10, so that if some of them drop, the others will continue. And as an attorney, as a lawyer, you ought to have the best interest of the client at heart. So when they want to drop out, they will drop out, but the ones that don't will carry your strategic strategic litigation interests. And the other things you need to think about when thinking about clients is there a potential for clients to start fighting among each other if you have a group, especially in economic, social, and cultural rights. But with women's rights, might there be a possibility where if the respondent is a company or the state, and they incentivize some of them to split, is there a possibility that the clients will split? And if they do that, what do you do? So you need to think about those things early on. And you also need to think about the nature and temperament of the client as well. Is your client predisposed to going out and making public statements that harm your strategic litigation goals? Would the client switch sides? These are things. Would the client is the client a reliable partner? Is generally what I'm trying to get at. So I think I've gone through. Oh yes, okay. So and sometimes you could also pick your client based on how they can aid your public communication strategy. So if you have a client that is more predisposed to being more presentable and taking out and fighting for the cause, that might be a better client for you. So once you've done that, then really so far all of what we've discussed is legal work, but this is where you're getting to the stage where you're actually starting to write an application. So at this stage, I would say, generally speaking, you need to if you aren't already familiar with that field, you need to familiarize yourself with both the domestic legislation and international standards. If it's a complex case, it might be a good idea to pull in academics from the university, from the Human Rights Center, or people who specialize in that field, because you don't want to miss anything when you're writing your application. And this is where I would pause and discuss with you that so you have the client's interests, and the client is the one who's taking the case. You could also be the client, if for example, you're an institution and you want to sue the government or sue a certain entity. But generally speaking, you have a client, a victim, who's your client, and then you have your strategic goals that are specific to that strategy. So far, we've been using the example of the equality of women in the workplace, and so you have those strategic goals. But then you also need to, at the same time, consider the strategic goals of Ethiopia, or the strategic goals of entrenching the rule of law in Ethiopia. That is important pretty much for every case that comes through the Ethiopian legal system. So I'll give you a list of issues that I consider, but those won't be exhaustive. so when you do your case selection, or you've already selected your cases and you're litigating, you should be conscious of a number of things. First, you should think about, or I'll say example number one is you should try to set precedents in Ethiopia where courts take judicial notice of international human rights law. So I will not get into the details of this. In Ethiopia, the constitution is progressive in that it makes international law, and especially human rights law, part of the law of the land. So much so that the constitution is supposed to be interpreted, and sometimes it is interpreted in light of international law and international human rights law and jurisprudence. But in practice, you can't even cite international law because the treaties that Ethiopia signs are not published as part of the Nagarit Gazeta. So, so you need to take that into consideration. Put in pretty much all your applications, think of ways you can argue that the court should refer to international law, refer to international treaties, or if possible even international jurisprudence in a binding way, and build that up all the way to the Supreme Court, the Court of and the Court of Cassation, or even the House of Federation. The other thing that I feel should be considered in every case, or at least taken into account, is challenging what could be called austere legislation. In Ethiopia, you have legislation that sometimes even regulations that take the powers of the courts and give it to administrative agencies and to executive bodies. This practice erodes the capacity of the courts and erodes even the capacity of the legal profession to effect social change. So that is something, and I suppose this is something that will be covered in your materials, in your PowerPoints. So that is something that you need to consider. The other example I usually refer to is in Ethiopia, the constitution sometimes doesn't necessarily, will not, usually will not contain all the international standards you find in international law. Two examples may be the situation with the state of emergency, for example, is the list of derogable rights in the Ethiopian constitution is different from the list of non-derogable rights is different from the list of non-derogable rights in international law. So that could be something that may need correction. And the other issue that you need to consider within the constitution is there are some rights that the constitution does not contain. For example, the right to food is a good example. Of all rights, the right to food is not contained in the constitution. So where the constitution is not in par with the international law, and it usually isn't because the constitution is not detailed, you need to think of ways of interpreting the constitution in light of international law so that standards of human rights are generally raised. And the other common example that falls within this category is the clawback clauses of the constitution are, to say the least, imperfect. So in international law, in order to limit human rights, there are specific criteria put on every piece of legislation. The first, is that limitations need to be prescribed by law. The Constitution contains that. But everything else that follows, the principle of proportionality, the principle of necessity, the Constitution does not. It contains in some articles, but it doesn't in most. So one of the things I suggest that every lawyer engaged in strategic litigation is to try and put these things into their application. So you're not only dealing with women's rights, you're saying, yes, the limitations on the women's rights can be imposed, but in accordance with these principles. And we'll not go over the principles, but that is something that should probably be put into every case. And the other one is justice for, in Ethiopia you have rounds and rounds of serious human rights violations that haven't been met with justice. A good example is the Red Terror in Ethiopia in the 70s. We had the Red Terror, and then those individuals were put in jail, but really I will not go into the details of it, but from the point of view of transitional justice, you don't have precedent in Ethiopia where violators of human rights, serious violators of human rights aren't put to justice. That is something that you need to look into as individuals engaged in strategic litigation. The other one is, earlier I was talking about you should submit amicus briefs, and then there's also the actio popularis, where there was one attempt by Action Professionals Network which attempted to bring actio popularis case to Ethiopian courts, which wasn't successful. So basically the issue is, if you're not a party, so far we've been talking about clients, and so far in Ethiopia, if you're not a direct victim of human rights violations, you cannot bring a case unless you bring that victim with you. But if you can inculcate that principle of actio popularis in your cases, you can start a precedent where you can bring a case although you're not a direct victim. And even amicus briefs aren't practiced in Ethiopia. So amicus and actio popularis are two mechanisms that help litigators like yourselves to bring cases, or to make it easier for you to bring cases that are of social importance. So that is one of the things you need to consider. The other segment I would, is just some cautionary tales in your applications, is that you should map what your application will look like, not just at that moment. Don't look at just the specific client. When you're engaging in strategic litigation, you look at the big picture, not just the big picture of what the cause is, but also think about what happens next. If you win this case, or if you don't win, appeal. Like, what do you appeal? What applications should you, what kinds of ideas can you come up with to include in the case to broaden it a little bit, so that on appeal you can use some mechanisms. And the reason you want to do that is because if you have a narrow view at the court of first instance and you miss potential arguments, what happens is after 5 years of litigating, you might find out, if I had just included that argument. So you need to think even 10 years ahead, even into taking that specific case into international courts or regional courts, or the African Commission on Human and People's Rights. At that stage, is this case strategic enough that I will take it all the way up to the international level? And if not, then you should question whether that is a strategic case. One example I'll bring up is the Anuak Justice Council case, which was argued at the African Commission, and it's a really well written application. But when it comes to our discussion of strategic litigation, even though the case was well argued and well written, if you ask yourself, so what were they trying to achieve? You don't see that strategic aspect of the case. And basically the case was taken to the African Commission on Human and People's Rights, and it did not pass the admissibility phase. And if it was taken as a strategic case, it might have passed the admissibility case, because the lawyers and the non-lawyers involved would have anticipated what might happen and reacted to those, to losing the case. Another really good example is the Human Rights Council and Others versus Ethiopia, which started at the first instance courts and went all the way to the Supreme Court and went all the way to the African Commission on Human and People's Rights. And that case also didn't make it through the admissibility phase, because, and this is, why being exhaustive is important, because the small set of arguments that weren't raised at the first instance became an obstacle in the end, because the lawyers did not anticipate going all the way to international tribunals. So when we're talking about strategic litigation, we should have that long view, and this took quite a number of years before it got to the international level. So just missing one argument, not having that big picture, can harm you going down the line. So, and when I say argument, also substantive argument. That is why earlier I recommended consulting academics who specialize in that field, because you might find yourself learning about the substantive area, and then by the time you've gotten so far, you find out, oh, if I knew better, I would have done it differently. So getting it right in the beginning is really important. So although it will feel awkward, investing a good amount of time at the early stages will pay off in terms of the strategic angle of what you're doing. Let's see. So yes, we've covered those. So the next step is when you're going to strategic litigation. I don't think I have the big picture. As you got Katanark. Okay, no big deal. Okay. So when you go to the next stage, the next step is, okay, you have an application in the court, and as to take you back to the previous slide of the big picture of what you're doing. By this time, you would have learned about whether there are others engaged in strategic litigation. You would have a good picture of what else is going on, who else is doing what in terms of public engagement, in terms of changing the culture, in terms of changing the curriculum, in order to attack the problem from many directions. So by this time, you would have a good idea of who is doing what and what is going on. So the next question is, you submit the case, but then it doesn't end there. You would have to maximize the benefits of submitting the case. Sometimes it is better not to publicize the case, depending on the situation, maybe depending on the risks. For example, risk of repercussion from the government may be low if the government is the respondent, and if the risks from the government are low, but risks from social actors doing something bad to your clients is higher, then maybe you don't need to publicize. So publicity is not always a good thing, but let's say publicity is a good thing. So at this stage, you have either made your application or are very close to making your application. And as I said, these are recommendations. It's not a set of rules that you have to follow very stringently. So this exercise, this stakeholder identification exercise, might be done a bit earlier, depending. So at this stage, you have either started your application, or you have either made your application or are about to, or very close to it. So now the question is, within the big picture, what are you trying to achieve? If what you're trying to achieve needs publicity, then you might go for publicity. But if it's something that you need to keep a low profile at that moment, maybe publicity will come later. So the question is, within that big picture, how do you maximize that litigation in order to achieve your goal? How do you make sure that it's not just a court decision, but it's more than that? And one of the things that I would recommend you do in this process is do a stakeholder identification, do a stakeholder mapping, map out, and you can do this as part of earlier exercises, but you need to have a good idea of, when I make that application, when I take the case to court, these are the institutions that would be interested. Those institutions might be funding institutions. Those institutions might be, and speaking of clients also, one thing that I maybe forgot to mention earlier is that maybe what you also need to set up your client with counseling services, social, psychosocial services, because your client might need that in addition to the legal services you have. So you need to find out what counseling institutions there might be, or generally speaking, what institutions will help your client and help your cause and collaborate with you. If you're talking about women who are victims of abuse, you might need to have a relationship with institutions that provide support, that provides protection. Law enforcement institutions might be your allies in certain situations. So you need to figure out who will be impacted by your application and who would be interested in your application. And you need to have a good idea of who your allies are, who might be funding your case, who might be finding you expert witnesses, and maybe you need to link with artists who will help you with the public advocacy part of it. Maybe you need to have a relationship with newspapers, journals, so that you synergize your efforts with the media, or when you call out for a press conference, you need to make sure that you have a relationship with journalists so that they actually come to your press conference. In addition to identifying your allies, you also need to identify potential opponents who might not be parties to the litigation, who might be, for example, who might come out with a public campaign against your case when your case makes the news of your application makes it to the media. So if you know who those individuals are, or if you have a general understanding of who they are, then you can prepare or anticipate what you will do when they start, say, making a public campaign against your client or your cause. And you should also have a view of what your approach is to the general public. What kind of communication strategy you will have. In certain contexts, you might even want to hire someone to help you with putting together a communication strategy, because you anticipate, the government or different social actors to come and oppose you. And so how are you going to approach the public so that the view of the public doesn't go against you? And if that happens, especially in a democratic context, you want the public to support you. And in a context of law enforcement, you want the public to support you. So how are you going to approach the public is always something that you need to consider even if you don't have a detailed communications strategy. So your general the general question here is, how do you increase the impact of your strategic litigation? When while you're doing while you're going through the litigation, you can use, I just put these as an example of if you want to change legislation, for example, or even change the constitution, or at least reinterpret the constitution, then you need to at the same time have other projects going on. You need to have a communications project going on, and so I've made a list of the things you can do. It's not even an exhaustive list. It's everything I could fit in one slide. So you have to have a dynamic approach, have to have partners you're working with. So you need to synergize with the different efforts to make sure that your case has maximum impact.